Good morning, everyone. Welcome. So glad to have everybody here early this morning. We're going to get started in about 1 minute, and I'll continue to let folks in throughout the event. And if you want to do a quick introduction of yourself in the chat, who you are, where you're coming from.
If you have any specific questions or areas that you want me to cover, feel free to put it in the chat also.
All right, well, we're going to get started. I know Bonnie and I have been talking, so you might get some time back a little bit later. But again, if you have questions, feel free to put them in the chat. Feel free to introduce yourself in there as well. Welcome to OEN's virtual education event, Foundational Contracts for Startups. I am Riley O'Brien. I'm the engagement specialist here at OEN. And we're giving Kara a break today so she can stay. She could be off camera if she wants, but we're excited to have you all here this morning. Just some communication guidelines. We have all of you muted. If you could stay on mute, unless you have a question during the event. Bonnie's open to folks opening up their microphone to ask any questions, but it allows us to, not hear. I've got some arguing going on in my kitchen right now, kids getting ready to go to school. So you're also welcome to stay on video if you want to. And then you're welcome to ask questions by taking yourself off of mute. But you're also, you're welcome to put them in the chat or send them privately to myself or Bonnie throughout the event, and we'll answer those as we continue to go. So excited to have Bonnie and Clementine Legal as our sponsor of this event. They're also sponsoring our AO Tech programming, which a lot of you are a part of this year. And again, we're really excited to have virtual programming at OEN, and we're looking forward to potentially continuing this throughout 2023 with topics and information that you all need as founders and entrepreneurs. And I'm delighted to welcome Bonnie Page, who's the founding member of Clementine Legal. I've known Bonnie for years. She's just a stellar human being and so incredibly smart. So we're delighted to have her here presenting. So welcome, Bonnie, and the floor is yours.
All right. Well, it's nice to see everybody's faces today. I'm just going to pop up my slides. And 1 second. All right. Can you all see my screen? Good. All right. It's nice to be here this morning. Welcome to Foundational Contracts for Emerging Companies, Foundational Contracts for Startups. As Riley said, my name is Bonnie Page. I'm the founding partner of Clementine Legal. I've been a technology and business attorney for the last 16 years. A lot of my career was spent in-house, and the last 3 years spent in private practice. I like to say that I've seen just about any issue that a small business or a startup will encounter. I've raised funds, I've sold businesses, I've started businesses. So think of me as kind of a wealth of startup knowledge. As we go through the presentation today, I'm happy to take any questions that you might have. If it's real kind of in the weeds, I might say, let's connect later so that we don't spend time kind of rabbit holing, but please do ask questions as I go through. And if there's something that you don't understand, please feel free to raise your hand and I'll go into a little more detail on whatever that topic is. All right. So foundational contracts roadmap, all of you are starting businesses. So you've gone through or are going through the formation process. So we'll talk about some of the contracts that are important during that formation stage and why they're important and the things that you need to look out for. Once you've formed your company, you probably go on to the next step, which is seeking out advisors. Advisors are people that you usually bring on to help with either sales or something strategic, or they have a lot of industry expertise. And a lot of times startups want to compensate those advisors with equity. So we'll go over how you do that and what contracts you need to have in place with your advisors. And then as you're building and selling your products and services, You might engage third parties to do some outsourced development, or you might hire an engineer on a part-time basis. Like, what kinds of contracts do you need at this stage to make sure that your product is protected? And then once you start selling those products and services, what contracts do you need with your customers in order to contemplate IP protection or confidentiality or other items? Once you've got a little bit of product market fit, you usually go into capital raise, fundraising process. So we'll go through some of the contracts that you might be aware of now or might be put in front of you when you start the fundraise process. And then finally, once you've raised some money, usually that's the time that you're ready to bring on employees. So we'll talk about some of the contracts that you need to have in place with employees as you start to hire. So formation. Throughout the presentation, I've got some Warren Buffett quotes. I'm a big Warren Buffett fan. So the most important thing in a partnership is that everyone has the same understanding of what the partnership is and what the objectives are. And I think that really summarizes what formation stage is all about and the contracts that are required in that formation stage. You're likely going to have co-founders at this stage, and it's really important to ensure that everybody's on the same page about what roles and responsibilities are, about equity, about vesting, kind of all those key components. I like to think of the formation stage as like getting married, and your contracts are really your prenup. And oftentimes you won't even need the terms of the contract, but they're really there in case things go poorly and the relationship breaks down. So it is important to kind of think of those things at the outset. So the first contract we're going to cover for the formation stage are the bylaws. The bylaws are really the governance documents for the corporation. They set out the how directors are appointed, how meetings happen, how shareholder meetings happen. They set forth whether or not the company has different committees, and how those meetings can be scheduled and occur. So the bylaws have to be consistent with a certificate of incorporation. The certificate of incorporation is filed with the Secretary of State. And at the early stage, your certificate of incorporation is probably pretty simple. It will get more complicated as you start to take on investment. And the certificate of incorporation will start to include some of the rights and preferences that your equity may have. So if you start granting preferred equity, the certificate of incorporation is going to reflect that. So you do want to make sure that the bylaws don't conflict with any other governing documents, like the certificate of incorporation or the shareholder agreement, which we'll talk about in a minute. It also covers indemnification of your board members and your officers. And so what that means is that if your board members or your officers are sued by a third party, the company steps in and will cover the costs of that lawsuit and cover the defense of that lawsuit. That's going to be really important if you're bringing in third party or outside independent board members. They're really going to want to make sure that the corporation is indemnifying you. So that should be included in your bylaws. It's also going to go over the procedural mechanisms for how you appoint and remove a board member, which is also, and replace a board member, which is also really important and you want to be aware of, because as you go through the fundraising stage, one of the things that will happen is the funders will do due diligence on your corporate governance. So you want to make sure that you're appointing, removing, and replacing your board members in accordance with your bylaws. And finally, they'll give you the kind of outline of how the corporation can take action. And usually the corporation can only take action in a meeting unless the bylaws say that the corporation can take action by written consent. So those are the two ways that the officers and directors affect corporate actions, is either in a meeting or through a written consent. So anytime you issue shares, there should be authority for that through either the minutes of the meeting or through a resolution. For the most part, the bylaws are pretty procedural. The really exciting stuff happens in the shareholder agreement. Any questions there?
Looks like there's a question in the chat, Bonnie. Would an exit clause be appropriate in governance documents?
An exit clause? Not typically. I think if you're talking about, well, let me ask you what you're referring to first.
Karen, do you want to come on mute?
Hi, yes. So being a startup, I am thinking about the end in mind before putting contracts together. And I just want to understand how much of our exit strategy needs to be included and protected in contracts. Especially,
yeah. Absolutely. So the bylaws would not have anything related to exit. These are pretty procedural. They talk about kind of the governance and the operation of the corporation. Any type of provision relating to an exit will either be in the shareholder agreement or the certificate of incorporation. And I think what you're probably in the shareholder agreements, the equity investment agreements, or the certificate of incorporation. And what you're probably talking about is liquidation preferences.
I'm learning, so keep yeah, I'm not quite sure what needs to be included. Obviously, equity and any assets we have, but also debt and
Absolutely. So terms related to an exit will be included in the investment documents between your investors or the certificate of incorporation or your shareholder agreement with your early founders. Kara, do you have a question?
I do, because I noticed that someone is starting an arts nonprofit, and as the new executive director of OEN, having to go through the Secretary of State to recertify the organization, like this is still applicable to nonprofits. This is how anyone starts an organization, correct? So like, I think
Absolutely.
that's an important thing, because I did not know that when I got into this.
All right, so the shareholder agreement is going to be the agreement that is between you and your founders. This is before you've taken on any equity investment. And the shareholder agreements are really important, as we kind of spoke about earlier, because it ensures everybody's on the same page. It's going to discuss the composition of the board. If you have multiple co-founders, how do you determine who's on the board? Are you all on the board? Any stockholder approval rights, if there are specific things that require either a majority, supermajority, or unanimous vote, those would be laid out in the stockholder agreement. Restrictive provisions such as confidentiality requirements, non-competes, and non-solicits. Those are really important as you're developing IP. You don't want one of your founders to walk away with the IP if things kind of break down. Transfer restrictions, also another really important term in the shareholder agreement that restricts the right of any founder from transferring their equity. It would also usually include a right of first refusal, which means, or a right of first offer, which means that the company or the other shareholders would have a right to buy any shares that any founder wanted to sell or attempted to sell. If you have a non-founder shareholder, they might ask for information rights, depending on what percentage they own. And that means that they have rights to certain information about finances, or product development, or things like that, kind of at that stage. There may be different voting rights depending on how your shareholder, your founder group is set up. You might have certain types of shares that have super voting rights, or you might have certain types of shares that have no voting rights. One of my favorites is the drag-along right provision, because I just worked a deal where a company didn't have drag rights, and it made the acquisition a little bit more challenging. So what drag rights mean is it's the ability to drag along a minority shareholder if they decide that they don't want to sell their shares. So they're basically forced. It means that a minority shareholder cannot hold up a deal where the majority has voted for it. And there are other ways to kind of deal with minority shareholders if you don't have drag rights, but it's more expensive and time consuming from a legal perspective. So definitely an important provision. And then last, distribution of assets. If things don't end up working out. And I think that to answer Karen's question earlier, that's another kind of liquidation term. But that would be more in a situation where you're winding up the business instead of selling and going through an exit. Shareholder agreements will generally be replaced at your Series A or Series B with a standard set of VC documents. Usually these forms follow the structure of NCVA, which is a public organization that puts out form documents. So you can go onto their website and take a look at all of their form documents. But these look like a voting agreement, investors' rights agreement, and then a share purchase agreement will go along with those when you go through your first price round. Any questions there? Restricted stock. So restricted stock is what companies usually issue first. Restricted stock is stock that vests over a period of time. So the holder actually owns the stock, unlike a stock option where the holder owns a right to purchase stock in the future. With restricted stock, you actually hold the stock. But if one of the founders ends up leaving before the vesting period has completed, the company has the right to buy back the unvested portion of those shares. So it's a really good way to kind of protect the founders that stay in the business. If it happens fairly regularly where one founder decides they no longer want to continue, and this is a way to make sure that that founder doesn't continue to receive the benefits of the efforts of the founders who stay. So the important provisions are vesting. Obviously, that's really important. Traditional or standard vesting is usually 4 years with a 1-year cliff. So that means that the stock vests over a 4-year period, but it doesn't start vesting until the first 12 months is up. And after that 12 months, the rest, about 25% vest, and the rest vest over the next 3 years. Par value is often overlooked, but kind of important if you're a Delaware entity. Par value is it's usually represented in the documents as being 1,000th of a cent. And if you're a Delaware entity, it's how you determine franchise taxes in Delaware. I don't usually recommend that startups incorporate in Delaware from the beginning, even if they're taking on investment. I usually recommend startups incorporate in Oregon. And then when you go through your first VC round, the VC may want you to convert to a Delaware entity. The reason why I don't recommend that is because of this par value concept in the franchise tax. If you don't set up the Delaware and corporation with par value and franchise tax in mind, you could be hit with kind of a larger franchise tax than you were expecting to pay. You also have to maintain the entity in both Delaware and Oregon, which at the beginning doesn't really make sense. So I usually tell startups incorporate in Oregon and then wait to convert until you take that investment round. Restricted stock typically includes an acceleration of vesting. So that means that if the company is acquired, there's some sort of acceleration. So all of the unvested shares become vested immediately. And if there's a liquidity event, then that individual would then be able to liquidate all of their shares for whatever price the investor was paying. Vesting can be single trigger or double trigger. And what that means is single trigger is they accelerate on a change of control. And double trigger means they accelerate on a change of control and that person is terminated in connection with that change of control. I see the double trigger a little bit more typically. Restricted stock also includes a right of first refusal. So a holder of restricted stock can't transfer that stock without the company having a right to buy it first. It might include what's called a co-sale right, which means that if the company sells any stock in the future, the holder can sell their stock along with the company at the same price. And lastly, the 83B election is really important because it's a filing that you make with the IRS. And what that does is it says that you elect to be taxed on that restricted stock when it's given to you. And the reason why you would do that is because it really doesn't have very much value at the beginning. So your tax is going to be very low. If you don't file an 83B, you are taxed at the liquidity event date. And that could be a substantially higher valuation. So definitely something that you want to file with the IRS. Restricted stock is usually granted in early stages versus stock options because that stock is taxed on the grant date. Usually at this point in time, the company doesn't have a lot of value. So the taxes are very, very low. As the company starts to increase in value, whether that's taking on investment, or selling products. Restricted stock is not the vehicle that you want to use to grant equity. At that point, you typically transition to an equity incentive plan and grant stock options because those are not taxed on the grant date. Any questions there? Oops. Founder stock. A lot of times you'll hear about founder stock, and it's really no different than restricted stock. The only differences might be that the vesting terms are a little bit different. And the reason why you would want to have founder stock in place before you take investment is because once you go out for VC or PE investment, they're usually going to require the founders to agree to some sort of vesting terms. And so if you have it in place before you go out for that investment, they're less likely to renegotiate those terms as long as they're reasonable. If you don't have any terms in place before you go out for investment, they're going to ask for vesting terms to be included.
Quick question on that, Bonnie, is that something that you should have? It sounds very odd, but you should have kind of a moderator between you and your founder to talk about founder stock, or is that something that's usually pretty understandable between founders?
In terms of percentage,
what percentage you'll both be doing prior to going out for funding?
Yeah, so I mean, it depends on how many founders you have, and it depends on what roles they're playing. But you typically see, so a company that is going to look for investment is usually set up with about 10 million shares of stock, and the founder pool is usually 5 to 7, depending on how many you have. That gives you enough equity ownership so that you still maintain control as you're going through advisor grants. But it really depends on what each founder is bringing to the table. If one founder is bringing only sweat equity and one founder is bringing investment, or if one founder is building the product and the other founder is doing the sales, it depends on kind of the negotiation between the two founders or the three founders or what that structure looks like.
Great, thank you.
Advisors. So once the company is set up, and once equity has been issued, this is a chance for startups to go out and look for industry experts or advisors that have done this before, have been through a sale before, have been through fundraising before, and they really provide sort of strategic advice on how to move forward and how to scale and how to build the company. Advisors are typically given some sort of advisor agreement, and the type of advisor agreement depends on what type of advice the advisor is giving. Advisors typically take a percentage of equity, and that can be between 0.25% and 1%. And you really need to think about kind of the ROI of that advisor's advice, because at this stage, you don't want to start over granting equity. So they should bring valuable industry knowledge, network connections, experience with the startup, or other really valuable kind of advice. The agreement should include their obligations, kind of what you expect them to deliver. And they really should be objective instead of subjective, so that you have something to kind of to tie their obligations to. They'll also include confidentiality provisions protecting the startup's confidential information. And then they typically include an indemnity provision. And that indemnity provision typically runs to the advisor. So that means that the company is going to indemnify the advisor if the advisor is sued because of something that the company did. So one of the things that you want to look out for in advisor agreements is whether or not the advisor is going to provide intellectual property to the startup, or if the advisor is really just going to be giving high-level advice or making connections. If they're going to be providing intellectual property or advising on product development, then it's really important to include an intellectual property ownership and assignment provision. And the reason why, this will kind of be a theme throughout the rest of the presentation. When you go for investment or when you sell your company, your investor or the acquirer is going to look to tie back the intellectual property to make sure that the business really owns it. So in any agreement that you have that the individual or company will touch your intellectual property or touch your product, you want to make sure that you have an intellectual property ownership and assignment provision included in that agreement. Advisor equity will also vest And it's usually a 4-year cliff, just like the restricted stock, although you can do different things. It's just that's what's typical. Confidentiality and invention assignment agreement. This will come up in a couple of places also. This is an agreement that is a standalone document that covers things like confidential information, solicitation of employees, creation and transfer of intellectual property ownership to the company. It may include a non-compete, and also, I think the last part is kind of what we covered before. But again, this is really necessary to tie ownership back to the company and to make sure that your investors are comfortable that the company does own all of the intellectual property that it's creating and selling.
A question came up in the chat, Bonnie. It says when granting equity, is it about 0.5 to 2.5 total for all advisors or each advisory member?
So you 0.25 to 1% per advisor is what's typical. But again, it depends on what that advisor brings to the table. So I've worked with companies that have advisors who are actually kind of getting into the product and doing a little bit more like hands-on. And those advisors were compensated with a little bit more equity. So if you've got somebody who's just making introductions or maybe will sit on your board, that's usually a little bit more like 0.25%. But if you have somebody that's really in the product and providing more product advice, or is going out there and selling, those are where you get a little bit more equity. So I'm going to cover a few intellectual property concepts here, just to set up the rest of this section. So intellectual property kind of comes in, and I'll say 4 flavors: copyright, trademark, patent, or trade secret. Copyright, trademark, and patent are all rights that arise under specific laws, and you register in order to get those rights. So copyright, you have to register with the Copyright Office. Trademark, you register with the USPTO, and patent, you register with the USPTO. Copyright is kind of any written or creative work in software is protected under copyright. Trademark is your brand. It's the name and the logo. And patent is a useful invention. And patents are obvious. Patents are the hardest to get. Copyrights are the easiest to get. You just need to put something into a tangible work in order to get copyright protection. Trade secret's a little bit different because it arises under common law. And so instead of registering for trade secret protection, it's something you get by virtue of keeping it secret. So the famous example is the Coca-Cola recipe is protected by trade secret. They never release it. You can only get your hands on it if it's under NDA, and everybody who has their hands on it is vetted and make sure that they understand their obligations. With trade secrets, if you don't protect it, you lose the right. So confidentiality agreements are really important for protecting trade secrets. Copyright, trademark, and patent, those are all registered and made publicly available. So anything created before it's registered, you might want to spend the time protecting. But once it's registered, it's in the public domain and it's protected by either copyright, trademark, or patent rights. So the important provisions for protecting intellectual property are ownership and licensing. So in each contract that you enter into to either sell your products or incorporate third-party materials, there will be an ownership provision and a license provision. The license provision will grant the third-party rights, but it's a subset of rights. So they don't have ownership over the intellectual property, but they might have the right to use it in a specific way. They'll usually include confidentiality clauses to protect those trade secrets. They'll include a reservation of rights section, which protects if you're licensing intellectual property. The reservation of rights section will basically state that you reserve all rights that aren't specifically licensed. The other thing to consider is open source or third-party materials, which are made available under a different license. And you might not have the right to transfer ownership or to license specific things to the open source components or third-party materials. One comment about developing products. I know a lot of startups who look to third parties to help develop their IP. And if you're looking to a third party in another country, you have to be careful about understanding whether or not contracts that you have in force or in place to protect that IP or to protect that development are enforceable. You also have to consider the costs that would be necessary to enforce those agreements. And so while it's very economical to use developers in third countries, you do need to be cognizant of who those developers are and if they have a good reputation. Because if you had to go enforce those provisions, it would probably be too expensive and too onerous to actually be worth it. Any questions there? That leads us into software development agreements. And this is specifically software development agreements with third parties to help you build your product. So what's important in the software development agreement is the transfer of ownership. It goes back to what we were talking about earlier. Your investor or acquirer is going to want to tie all IP back to the company, and they'll want to make sure that any software development firm that you have an engagement with, you also have an agreement with that transfers the ownership of those developments to your company. It'll typically include time and materials or milestone-based payments. And this is something that you really want to make sure you understand, because if it's a milestone-based, then the company is required to deliver certain things to you at certain times. If it's time and materials-based, the company is just charging you an hourly rate. And if the development does not meet your needs or not meet your criteria, you might be paying for rework. So understanding exactly what the company is required to deliver to you, whether or not you can test that material and accept or reject it, and whether or not that development shop will be providing that rework for an additional fee or if it's included in that acceptance testing process. And then if you need ongoing support and maintenance from that development shop, what does that cost? What does that look like? You will also want to restrict them from including third-party materials into your developed IP unless you understand what those are. And that's getting at open source again, because as we all know, some open source license have viral components, and you don't want those viral components included in your product when you go to sell or take on investment. And what will happen in due diligence is the acquirer or investor will ask you to do an open source scan or ask you to make a representation warranty to open source that's used in your software code. And if they find viral components, then it's going to cause a problem during that due diligence phase. Let's see. Terms of service and MSA, this refers to the terms of service that you're going to have in place between you and your customers. And these really should be reviewed in terms of the product that you're selling, any regulatory or specific industry requirements that may apply to the products or services that you're offering. Those should all be incorporated into the terms of service and MSA. You really don't want to, I've seen this happen with a few companies that I work for, where they've pulled somebody else's terms and conditions off of the web and then used those. And what happens is there are terms and conditions in those MSAs or terms of service that the company doesn't quite understand and may not apply to their business or may cause risk. So what's important in a terms of service or MSA? Protecting IP is common theme. Protecting IP and making sure that the license grants to the customer or to you as the provider are accurate. So if you're licensing them the right to access or use your software, or licensing the right to use some other material, or if you need a license from the customer in order to provide the service, that should be included. Confidentiality and how you can use information. This is becoming more of an interesting point with AI. Because a lot of contracts don't really contemplate the use of information for AI models or what that means. So if you are planning on using an AI model at some point, ensuring that you have the right to use any information that you've collected from the customer to do that is really important. Limitation of liability is important because it essentially is a deterrent from litigation. So if you have a reasonable limitation of liability and the contract is less than 100,000, it is less likely that the parties are going to litigate. So I always use the limitation of liability as a litigation deterrent. An indemnity is something that your customers will ask of you, and they usually ask you to indemnify them for intellectual property infringement, which means if they're sued for IP infringement for using your product, that you will step in and defend them and cover the cost of that lawsuit. They may ask for indemnity for different things depending on what the product or service is. See a lot of indemnity requests with privacy nowadays. And then there'll probably be product specific terms. Most of the time in your paper, your goal with the terms of service or MSA is to really limit your liability and limit your risk of delivering products and services. Last point I'll make here is that consumer facing products and B2B products are very different. From a if you're providing a consumer product, the arbitration and mediation terms are much more important, because you're really trying to make sure that class action lawsuits, you're deterring class action lawsuits. So that's the biggest difference between the two. But any questions there? Privacy policy. If you're collecting any kind of personally identifiable information about your customers or their end users, the FTC is going to require you to have a privacy policy. There's been a lot of talk about the US state laws that have gone into effect in the last couple of years. Most of those state laws have a revenue or records threshold, and that means that they don't apply to you unless you're over 25 million in revenue, which is California's threshold, or unless you collect a certain number of records. And California's threshold right now is 100,000. So a lot of early stage companies aren't going to meet the thresholds for CCPA or some of the other state privacy laws to apply. That not all of them. So Washington is in the process of passing a law that does not have a threshold. So it's something to be aware of. Also, if you're subject to specific regulatory privacy regulations, those won't have the same threshold. So a couple of those are biometric data, financial services data that's regulated under GLBA, healthcare data that's regulated under HIPAA, or if you're selling into the EU under GDPR. So if any of those privacy components or privacy regulations apply to you, the things that you want to make sure that are included in your privacy policy is how your data is collected, how it's used, and how it's shared. And if any of those state laws apply, foreign laws or the other federal regs apply to you, there are also specific terms that need to be included in your privacy policy. I always recommend that everyone include a cookie consent banner on their website, even if some of the privacy regulations that require it don't apply to you. And the reason why I recommend that is there have been quite a few wiretap trolls recently. And what the wiretap trolls will do is they'll click on your site. Your site will collect information about them, especially if there's maybe a Facebook pixel or some other third-party cookie on your site collecting information for marketing purposes. They'll send you a notice that your website has intercepted their communication, and they'll basically try to get you to settle. If you don't settle, they'll file for arbitration and try to get you to settle with them that way. So the cookie consent banner is the best way. You put it on your website. Somebody has to consent to the cookies collecting information before they travel through your website. The other thing that I will note for startups at this stage is when you're building your product, you should think about privacy while you're building the product. So it's called privacy by design. And what it means is that you're thinking of whether or not you need to collect the information that you're collecting, if it's necessary to serve the purpose that the application or the product provides. If you don't need data, then don't collect it, or find a way to anonymize it shortly after. Bake information security into code development as early as possible and keep up on your technical debt. This is something else that will come up in due diligence. And if you're thinking of information security and code development from the jump and you're up on your technical debt, you're going to fly through due diligence a lot faster. And again, special laws for regulated data. So if you're contemplating AI or if you're collecting biometric data, those are kind of the two new hot areas of the law. So privacy policy probably needs some special looks if you're doing either of those things. Any questions? Everybody's talking about AI and Chat GPT, so I thought I'd throw in a slide about these two, about AI and Chat GPT as it relates to contracts. So the thing that's really important with Chat GPT terms and conditions is no information that you input or receive from Chat GPT is confidential. So if you're using it as part of your product, you want to really be cognizant of what you're inputting into Chat GPT. There's also this kind of outstanding question of whether or not the output of Chat GPT can be copyrighted, because because copyright laws require human creation. And obviously Chat GPT is not a human. So that's kind of an open legal question. You won't want to include or an input PII into Chat GPT unless you've anonymized it. Otherwise it impacts privacy laws. AI laws are coming in the US and in the EU. So something also to be cognizant of, this is going to be a changing field. It's going to rapidly change as new laws are introduced. So I would recommend looking out for high-risk uses of AI, which means code development, because we don't know who owns the output yet. Hiring decisions, financial decisions, if what products or services you offer to an individual can change based on AI. Those are all kind of high-risk uses right now and should be evaluated. Any questions there? Is anybody using AI? All right. Raising capital. So once you get to the raising capital stage, securities regulation is the first thing that you need to be aware of. If you are offering a security, the SEC in each state require that you either register that offering or you have an exemption from registration. So what that means is that if you're offering a convertible note, which converts into preferred stock or common stock, that convertible note raise needs to be registered or exempt from registration. Same with safes, same with common stock, same with restricted stock, same with stock options. Most of these offerings do have well-known exemptions. So one of the exemptions that you might rely on is the intrastate offering, which is securities that are offered wholly within a state and not offered to investors across different states. So if all of your investors are in the state of Oregon, you can use the intrastate exemption, and you do not need to register with the SEC. You will still need to register with Oregon, but you won't need to register with the SEC or another exemption with Oregon. Other things to think about, it's really important to follow securities regulations. The risks of making an offering without registering or making an offering with incomplete or inaccurate information are very high. The offerer is subject to lawsuits by investors, and so is anybody who works on that offering. So accountants or lawyers also. So it's a pretty high risk area. The information that you provide to investors has to be accurate, and it has to be comprehensive. If you are making offerings to accredited investors, and that's a technical definition, you don't need to provide the same level of information to accredited investors, but the information you provide them still needs to be accurate and not false or misleading. Generally, if you're advertising the offering or making general solicitations, some of the exemptions will not apply to you, and you'll need to find more of a like a crowd fundraising exemption. You'll have to work with counsel to find that. Any questions on securities regulation? One of the most popular ways to raise money for entrepreneurs is a SAFE. A SAFE is not debt. It is a way for investors to invest money into your company without the startup having to pay that money back. What will happen is that it will convert to equity at the next price round raise. So the two important provisions in a SAFE are the discount and the valuation cap. And what that means is that when the SAFE converts to equity, the SAFE holder will get a discount on the next round. So if the next round, the investors are paying $1 for their equity, the SAFE investor will convert at 80 cents if they had a 20% discount. Safes also might include a valuation cap. So if the valuation cap were 4 million, the conversion will be completed as if the next price equity round valuation was 4 million, even if that valuation was 8 million. So oftentimes you'll see either or both the discount and the valuation in a safe. You as a startup owner want to make sure that the safe is being issued at a pre-money valuation or converted at a pre-money valuation and not a post-money valuation. Sometimes the safe holders will negotiate liquidation preferences, and this is kind of going back to Karen's question earlier. A liquidation preference means that the holder, once they hold preferred stock, might receive a multiple on their investment in a liquidation scenario. So if the company is sold, sometimes your preferred stock will have what's called participating preferred, and that means that they get paid out before the common, and then they convert to common stock and get paid out with common shareholders. You also might see most favored nation rights, preemptive rights, or major investor rights in safe. The important thing to look out for with safes is really understanding how it's going to dilute your cap table. And if you're raising multiple rounds or issuing multiple safes, making sure that you can keep track of conversion terms and keep track of things like most favored nation terms. Another way that startups will raise money is what's called convertible notes. Convertible notes and safes are fairly similar. The terms that you'll see in each are fairly similar. The difference is that notes are debt. They have interest rate, they have a maturity date, so they need to be paid back by a certain point in time. And if they aren't, if you get to the maturity date and you haven't had a liquidity event, the note holder will either be able to elect to be paid back or convert to common. One of the things to look out for with notes is the concept of shadow preferred. So you want to make sure that if you issue notes, they include a concept of shadow preferred, which means that the notes will convert at their issue price instead of at the preferred equity price, to ensure that the note holders don't receive a windfall on the next liquidity event. So for Series A, I'm just going to talk a little bit about preparing for Series A. Preparing for Series A, you really want to make sure that you have clear ownership to IP, that you can demonstrate through all of your contracts that you own the IP that's been created for the company, that you have clean corporate docs, and that you've issued any notes or convertible or notes or safes in accordance with securities regulation. So kind of following the path of all of the things that we've talked about before. You want to make sure that you're following your bylaws, that you have consents for all of the equity that you've issued, that you have documentation of securities compliance, that you've complied with the securities regulations in issuing that ownership or that equity. And you want to make sure all of your contracts with third parties clearly transfer ownership to the company. When you get to Series A, you'll have a new set of governing documents, the investors' rights agreement, the voting agreement, your certificate of incorporation, and you may convert to a Delaware entity at that time. And your Series A investor will likely have a board seat. So at the Series A stage, you start to give up control rights. You have external parties who will come in and have more control over how business decisions are made through board seats or specific provisions in these investor agreements. Hiring employees. So what typically happens is after you've raised some money, you develop a hiring plan and you start to hire employees. In Oregon, if you're hiring employees, non-compete clauses are not enforceable unless the offer letter includes a notice that a non-compete will be required. The offer letter has to be provided at least 2 weeks prior to the employment start date. So before non-compete laws in Oregon changed, it wasn't so important whether or not you used an offer letter. Now that we have this requirement in the Oregon statute, it's really important to make sure that if you are going to require a non-compete, that it's included in that offer letter. Some companies are now not including non-competes in their employment agreements, and they're just relying on non-solicitation of customers. That is a path that you can take. But I would recommend including the non-compete in your offer letter. And even if non-competes become unenforceable at a later date, at least between now and that time, you have an enforceable non-compete. The other provisions in the offer letter are salary, variable compensation, bonus, and equity. You do want to make sure that your equity in the offer letter doesn't conflict with any terms that you might have in an equity incentive plan. And you want to make sure that the variable compensation doesn't conflict with any terms that you might have in a bonus plan. Any questions on offer letters? Equity grants. So at an early stage, most founders, advisors, or other individuals who are working for the company are getting restricted stock. Once you go through an investment round, a price round, which is typically a Series A, or it could be a seed or pre-seed, if it's a price round, then you're going to want to start to transition away from restricted stock and start to make grants under an equity incentive plan. Under an equity incentive plan, you typically grant stock options, which are the right to acquire stock at a specific price at a future time. And these equity grants also vest. Typical vesting is just kind of like the restricted stock that we talked about earlier. They vest over a 4-year term. There's a 12-month cliff, and then everything vests ratably over a monthly basis after that. The exercise price is a price that you're going to want to determine based on a 409A valuation. And that will be the same exercise price for every employee until you get a new 409A valuation. Those typically happen on an annual basis. Equity grants usually have a repurchase rate for the company. So if somebody leaves the company and they have vested stock options, typically the company has the right to repurchase those vested stock options at fair market value, and they restrict the individual from transferring. Equity grants to employees are securities, so they do have to have an exemption or be registered. In Oregon, we do have an exemption, and it looks like I forgot to include the citation, but there is an exemption for equity incentive plans. Some companies use what's called shadow stock, which I actually really like. It's less common than stock options, but it's essentially it's a bonus that's tied to stock, so it has the same components. It has an exercise price, and it compensates individuals on the spread between the exercise price and the fair market value as the stock goes up, but it's not actually stock. It's just the right to receive a bonus that sort of tracks stock. I like them because they're very easy to administer. No rights accrue to employees until there's actually a liquidity event, but they're less common. Any questions on the difference between those two?
There's a question in the chat. It says, how is a shadow stock different from phantom stock?
Same thing.
And then another question, can you explain what you mean by exemption for equity incentive plans?
Oh, yeah. So like I said earlier, all securities have to be registered or exempted from registration, and they have to be registered federally or exempt federally or on a state by state basis. So if you're offering equity to employees who are in California, and in Oregon, you have to have an exemption for both California and Oregon. Equity incentive plans are typically exempted under state laws. So once you create what's called an equity incentive plan, and then you grant equity underneath that plan, you typically have an exemption. Does that answer the question?
I'll have Stephanie answer. Yes, it does.
Perfect. The other agreement that you're going to want to give to employees is the confidentiality and invention assignment agreement. And that transfers ownership rights in everything that the employees create to the company. Again, it's a really important document in tying out IP ownership. Typically, these agreements also have the restricted covenants, which are the non-compete, non-solicitation, and confidentiality clause. Right. And I think that wraps me up. I knew I'd be a little bit quick if there weren't a lot of questions. How about I open this up to questions, and if you guys have any contracts that you're currently negotiating or any burning questions about contracts in general, anything that I didn't cover that I can answer, I'd be happy to do that.
Feel free to open up your chat if you have, or your audio, if you have any questions directly for Bonnie.
Hi, Bonnie. This is Karen. Thank you so much. This is a really great foundation. I'm curious if there are certain windows that you want to limit adding new contracts to protect your, like, just to freeze your cap table. Like, for example, when you are going out for a funding round. And specifically, the question has to do with issuing employee incentives during those key times where it would be quite embarrassing for an employee to leave. But you also want to keep your cap table undiluted.
Yeah. So a couple of ideas here. So if you've created an equity incentive, if you've created a stock option pool, issuing stock options to employees under that pool will not further dilute you, because you've already contemplated the pool being maxed out. So do you have a stock option pool?
We do, yeah. I don't have the information. I'm not on the founding team.
Mhm.
So I know
that's
we have
how
a pool. I just don't know how much remains in the pool.
Yeah, that's where I was going to go next. So if you have a pool and you're going out for investment, you should think about whether or not that pool is big enough to continue to incentivize employees and advisors post investment. So you might need to increase the pool with that investment, and there might be enough runway left in that pool to incentivize the employee that you've mentioned. But that's how I would incentivize them before investment. I don't think it won't cause any issues with your investors if you're issuing more equity under that pool. But you don't want an outsized grant. So like, this person shouldn't receive an enormous grant that looks a little bit off. I mean, they should have a grant that commiserates with their position. So if there's somebody who's technical, if they're in sales, those types of positions tend to be issued more equity than, say, maybe somebody who's on the marketing team, or maybe a really fantastic administrative assistant. So you don't want to make a grant that sort of seems outsized for that person's contribution.
Okay, thank you. In full transparency, I would be the employee asking for. So this offers a lot of empowering strategy. Thank you.
Mhm.
Bonnie, there's a question in the chat that says, can you describe some best practices where an angel investor is also a board member, or where an angel wants to convert to VC level and additional investment?
Some best practices when an angel is also a board member. Well, in terms of governance, you'll want to make sure you're following your bylaws. And if that person has the right to appoint themselves or remove themselves and appoint somebody else, you'll want to make sure that you're following those kind of governance issues. I'm not sure. They will also want an indemnity agreement, most likely from the company as a board member, if they haven't asked for that. If they should also have an agreement protecting kind of confidential information. It's less likely when you get into kind of angel investors and VCs that they're going to agree to terms like non-competes, because they tend to invest in a lot of companies, and they might invest in a lot of companies that do the same thing. But you would want terms that protect your confidential information, especially if they're on the board of like a competitor. That's something to consider. If I didn't answer that question, please feel free to pop in a follow-up. Is there a general rule or cap for equity percentage for angels to leave the room for other investors down the road? So for angel investors, I'm kind of trying to interpret this question. What would tend to happen is if they came in on, say, a convertible note, when investors down the road come in, that convertible note will convert to whatever equity that investor invested, and usually that's a preferred stock. So usually the angel investor will receive the same rights as that investor, the same preferred stock. What will happen is that they will be diluted down. So their percentage ownership will shrink just like everybody else's as you continue to take on investment. If they wanted to, say, leave the room, if they wanted to sell, if they had the right of co-sale, then they might be able to offer up their securities for sale when that preferred shareholder came in. That's pretty unusual to have in a note, though, so I wouldn't expect that they would have that right unless they specifically negotiated it. Do angels and investors have to provide financial conflicts of interest? They do not have to provide financial conflicts of interest, but every shareholder owes a duty to the corporation. Every director owes a duty to the corporation. I would make sure that if you have somebody that you think has a financial conflict of interest, like they're invested in multiple companies that are kind of similar, that you have some sort of confidentiality agreement with that individual. If they're a minority shareholder, the information that they have the right to receive is a little different than if they were a majority shareholder. So that's something else I would be cognizant of. If I was dealing with somebody that had ownership or board members in competing companies, the types of information that you share with that person might be, you might want to kind of bound that a little bit more.
Any additional questions for Bonnie? Well, we're so appreciative, Bonnie, of you taking your time and you know, your thought leadership today, focused on contracts. Do you want to pop your email in the chat so folks can grab that and reach out to you with any additional questions, or if you want to connect with her about helping with any contracts you have coming up in the near future? I'm going to be sending this out to folks via email later on today, and we're going to be putting it up on our blog so folks can take a look at it. And if you have any questions, reach out to the OEN team about programming that we have coming up. But thanks so much to everyone for taking your time out today to be a part of the session, and we look forward to hosting more in the future.
Thank you, guys. Really appreciated it.
Thank you. Have a great day.
Bye.